All right, who wants to get super nerdy on something that's incredibly important, but 90% of the population is not going to give two shits about? First, I should mention uh, it is Thursday, May 22nd. It's about 8:45 p.m. when I am recording this. This is the third video like this that I am recording tonight. But one thing that, hang on. My brother had two things that he wanted me to do. I forgot to do one of them in the other two videos that I recorded tonight. He wants me to give him some facial expressions that he can use for the thumbnails on the YouTube videos. So let's do that. Okay, that should be enough. Second, he did make an accurate observation in that when it comes to like short sleeve, button up, button down shirts like this, I own an excessive, I I own an objectively excessive number of these shirts. And so he's like, I don't know, maybe you could change your shirt. If you're going to do 4 videos, maybe wear at least 2 different shirts, maybe 3 different shirts. So I did change my shirt for this video. All right, so now that we have that all of the way, the fucking Supreme Court. Okay. The Supreme Court did a really good thing today, and then they did this thing. The United States Supreme Court today killed the independent agency within the United States government. The headline that I'm looking at, says they made Trump a king. Slightly hyperbolic, but really not that hyperbolic. Essentially, the crux of this ruling today that the court issued on its emergency docket, that's also called the shadow docket, an unsigned majority opinion, all 5 conservative men, and presumably Amy Coney Barrett joined them. There's a dissent that we'll get to in a minute. So I'm going to give you an overview, and then I'm just going to read this opinion. It's 2 pages long. And then I'm going to read a bunch of the dissent. The dissent was 8 pages long. I have the opinion here. The dissent was written by Justice Elena Kagan. And she was joined in that dissent by Justice Sotomayor and Justice Jackson. Justice Elena Kagan is just... This is the nerd part. Justice Elena Kagan, her legal writing is just... Her legal writing, to me, it's like I'm in a custom-built log cabin in the mountains, in the Sierra Mountains, in between like Lake Tahoe and Yosemite. And it's this gorgeous cabin with like vaulted ceilings and like a 3-story, glass window thing with a wood burning stove, an incredibly comfy couch. And it's the middle of January and it's snowing like crazy and the snow is building up. And I've got a fire going in the wood burning stove, and I'm on this incredibly comfortable couch, with a couple of down blankets and some really comfortable pillows, and my dogs are with me, and I don't have any lights on. The only light is the fire light, but there are reflections so I can see the snow coming down. That's what Justice Elena Kagan's legal writing is like for me. Because, as I said at the outset, I'm a nerd. Anyway, let's dive in. I'm going to go through an article that gives a little bit of an overview of what happened today. And then I'm going to go through the majority opinion, such that it is, even though it's not signed by anybody and there's no indication as to who wrote it. And then we're going to go through Justice Kagan's dissent. The Supreme Court majority today all but declared that it is ready to overturn a nearly century-old precedent to protect independent agencies from at-will firing by the president. This is the last brick to fall in the division between the president and the parts of the executive branch that Congress created to be beyond his reach, turning the second branch of government into an all-powerful tool to be wielded by one man. He can fire whoever he wants from these independent agency boards that Congress, and for almost 100 years, the Supreme Court was like, you're not allowed to fire these people without cause. You are not allowed to just fire these people and replace them with your sycophantic ass-sucking toadies who will do whatever you want to do. The conservative majority on the Supreme Court today effectively overturned an almost 100-year-old precedent in saying, nah, he can do that. That's fine. That's fine. It's no big deal. He can do that. Let's just make him a monarch. Yeah. The case stems from Donald Trump's firings of members of the National Relations Board and the Merit Systems Protection Board, which he did knowing that he was not permitted to do legally because of a 1935 Supreme Court case precedent that we will call Humphrey's. That's the name of the case. So when I say Humphrey's, I'm talking about a 90-year-old Supreme Court precedent that explicitly says Donald Trump is not allowed to do this. But this court today was like, it's fine. It's fine. We're just going to let him do it. We know he doesn't have grounds to fire these people. And we know there's a 90-year-old Supreme Court precedent that said he's not allowed to fire these people without grounds. But it's fine. We're going to let him do it anyway. Because Donald Trump has effectively keistered the 5 conservative men on the Supreme Court. The Trump administration has aimed to get the Humphreys court or the Humphreys case before this Supreme Court because they apparently rightfully thought there were enough conservative justices that had bought into his idea of a unitary executive, a supreme presidency, that they would just ignore this case and let him do what he wants. And it turns out he was right. It turns out he was right. On Thursday, the Supreme Court overruled multiple lower courts that had reversed Donald Trump's firings in accordance with that Supreme Court precedent, hinting that the 2 agencies may not be protected from at-will firings. I'm going to save these quotes from Kagan until we get to her. The rest of this article is about her dissent. Okay. The case will bring the right-wing legal world closer than it ever could have imagined to a unitary executive, a previously inconceivably muscular presidency where the occupant of the Oval Office can reshape the entire executive branch in his image in violation of the Constitution, in violation of laws passed by Congress, and in violation of Supreme Court precedent that has been in place for 90 years. The 5 conservative men on the United States Supreme Court today were just like, that's fine. It's fine. Just let him, just let him do what it is that he wants to do. It's fine. It's fine. That 90-year-old precedent, it's like, whatever. Who gives a shit? Nobody cares. Nobody's going to read that. It's 90 years old. Who cares? It's 90 years old. Let's just let him do what he wants to do. Fuck those guys, man. So the case is Donald John Trump, President of the United States, versus Gwen Wilcox et al. I'm going to read this first paragraph of the, hang on, the 2-page, not even quite 2 full pages, majority decision in this case that is unsigned. We don't know who wrote it because the majority put this out on their shadow docket. The government has applied for a stay of orders from 2 other courts preventing the president's removal, firing, of a member of the National Labor Relations Board and a member of the Merit Systems Protection Board, respectively. The president is prohibited by statute from removing these officers except for cause, and no qualifying cause was given. If you read just that paragraph, you'd be like, oh, they turned him down. But you would be wrong. Because the conservatives on our current Supreme Court don't give a shit that the president is prohibited by statute from removing these officers except for cause, and that he has offered the court no qualifying cause by which he could remove these officers. It's like there are 6 cuck chairs amongst the 9 chairs for the members of this Supreme Court. 6 of them are cuck chairs. The application for stay presented to the Chief Justice and by him referred to the court is granted because the Constitution vests the executive power in the president. He may remove without cause executive officers who exercise that power on his behalf, subject to narrow exceptions recognized by our presidents. But who really gives a shit about our presidents? I mean, he's just going to do the thing, and it's like, whatever. The stay reflects our judgment that the government is likely to show that both the NLRB and the MSPB exercise considerable executive power. That's the fucking point, guys. But we do not ultimately decide in this posture whether the NLRB or the MSPB falls within such a recognized exception. That question is better left for resolution after full briefing and argument. The stay also reflects our judgment that the government faces greater risk of harm from an order allowing a removed officer, wrongfully, to continue exercising power than a wrongfully removed officer faces from being unable to perform their statutory duty. That's wishy-washy bullshit. A stay is appropriate to avoid the disruptive effect of repeated removal, reinstatement, removal, reinstatement, removal, reinstatement of officers during the pendency of this litigation. Finally, and here's where shit goes completely unpredictably out of the blue, off the rails. Finally, respondents Gwen Wilcox and Kathy Harris contend that arguments in this case necessarily implicate the constitutionality of 4-clause removal protections for members of the Federal Reserve Board of Governors or other members of the Federal Open Market Committee. Nobody said shit about that. We disagree. The Federal Reserve, the Fed, is uniquely structured, quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. So they've just said this thing doesn't exist. It doesn't exist. It's fine. Nobody gives a shit. It's not really a thing. Just let him do what he wants to do. Oh, but it really does exist when it comes to the Fed. Trump can fire whoever he wants to. He's firing people. You're fired. I'm fired. Everybody's fired, but you can't fire the Fed. You can't fire anybody for the Fed. We don't know why that is, but the Fed is different. Why is the Fed different? It is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. Oh, well, thanks for clearing that up, guys. I appreciate that clarification. Therefore, the prior orders are stayed pending disposition of the appeal in the United States Court of Appeals for the District of Columbia, until cert is granted to the Supreme Court. If cert is granted, then it depends on what happens there. If cert is not granted, then that's a whole other deal. Justice Elena Kagan, with whom Justice Sotomayor and Justice Jackson join, dissenting from the grant of the application for stay. For 90 years, the Humphreys case has stood as precedent in this court. And not just any precedent. Humphreys undergirds a significant feature of American governance: bipartisan administrative bodies carrying out expertise-based functions with a measure of independence from presidential control. That's been the law for 90 fucking years. And today, the five conservative, fart-huffing, mouth-breathing, MAGA chud men on the court were like, but is it though? Is it really? Nah, it's not. The two such agencies involved in this application are the NLRB and the MSPB, but there are many others: the Federal Communications Commission, the Trade Commission, the Federal Reserve Board. Congress created them all, though at different times, out of one basic vision. It is thought that in certain spheres of government, a group of knowledgeable people from both parties, none of whom a president could remove without cause, would make decisions likely to advance the long-term public good, instead of stacking these things with a bunch of fucking toadies. Like, well, is Trump going to put Steve Bannon on the Fed? Oh, God. And that congressional judgment, the Humphreys case makes clear, creates no conflict with the Constitution, rejecting a claim that the removal restriction enacted for the FTC interferes with the executive power. The Humphreys court held that Congress has authority in creating such quasi-legislative or quasi-judicial bodies to forbid their members' removal by the president except for good cause. And the majority today was like, whatever. I mean, it's fine. It's totally fine. Nothing's going to go wrong. It's Trump, man. What's he going to do? Everything's great. It's fantastic. The president believes the Humphreys case should be either overruled or confined, and he has chosen to act on that belief before this court has issued a ruling on that question. He was like, fuck you, I'm doing it anyway. And the court and the majority, the conservative majority, was like, yeah, that's fine. Okay, that's cool. He was like, fuck you, I'm doing it anyway, even though I know it's illegal. I know it goes against Supreme Court precedent. I know it violates the statute. I'm going to fucking do it anyway. And this conservative majority was like, have at it, dude. Knock yourself out. Our emergency docket, the shadow docket, while fit for some things, should not be used to overrule or revise existing law. I will add, that's been in place for 90 fucking years. We consider emergency applications on a short fuse without benefit of full briefing or oral argument, and we resolve them without fully or at all stating our reasons. It is one thing to grant relief in that way when doing so vindicates established legal rights, which somehow the courts below have disregarded. It is a wholly different thing to skip the usual appellate process when issuing an order that itself changes the law, which is what they did here. You're getting to see you're getting to see something right now. You're getting to see in real time a nerd get worked up. I don't think that's ever been observed in the wild before. Oh, God. And nowhere is short-circuiting our deliberative process less appropriate than when ruling requested would disrespect, by either overturning or narrowing, one of the court's long-standing precedents, like our nearly 100-year-old Humphrey's decision. Under that decision, this case is easy. As the courts below demonstrated, the president has no legal right to relief. Congress, by statute, has protected these board members from presidential removal except for cause. And again, the Humphreys case instructs that Congress can do so without offending the Constitution. For that reason, the majority's order granting the president's request for a stay is nothing short of extraordinary. That order consents to the president's statutorily barred removal of NLRB and MSPB commissioners, at least until we decide their suits on the merits. That's pending before the court. And the majority is like, whatever, who gives a shit? Who gives a shit? Nobody cares. Just let him do his thing. And so the order allows the president to overrule the Humphreys case himself, because the conservative majority is like, yeah, that's fine. I mean, whatever. We're going to overturn it eventually. So who gives a shit if he does it now? Because, I mean, whatever. Again, pending our eventual review, the court often reminds other judges that if one of our precedents has direct application in a case, they must follow it, even if they dislike it, leaving to this court, the Supreme Court, the prerogative of overruling its own decisions. The majority in this case just let the president, Donald Trump, overrule a 90-year-old Supreme Court precedent. That's what happened today. And they're like, whatever. And Clarence Thomas is like, are we done yet? I got a billionaire taking me to Greece. He told me there's going to be baby oil. It should go without saying that the president must likewise follow existing precedent, however strong he thinks the arguments are against it, unless and until he convinces the Supreme Court to reject what we have held to be the law for 90 years. Yet here, Fat Nixon, Pervert Hoover, Mango Mussolini, Tangerine Tits, Groper Cleveland fired these members, these commissioners, under the umbrella of the Humphreys case, not giving two shits in the world, betting that this Supreme Court would acquiesce, which they did. And the majority today obliges without so much as mentioning the Humphreys case. Okay. The majority opinion here is less than 2 full pages long. The controlling precedent that has been in place for 90 years, the Humphreys case, is not mentioned in these 2 pages. They overruled a 90-year-old precedent. Hang on. Excuse me. The majority... The conservative majority in less than 2 pages, overruled a precedent case that had been in place for 90 years without mentioning that case on those 2 pages. And then she goes into, she's like, oh, but apparently that doesn't apply to the Federal Reserve Board of Governors. The majority doesn't tell us why, except that there's a unique historical thing. Today, she closes with this. Today's order, however, favors the president over our precedent, and it does so unrestrained by the rules of briefing and argument and the passage of time needed to discipline this court's decision making. I would deny President Trump's application, and I would tell him to go eat a bag of dicks. Sorry, I added that last part. I would do so based on the will of Congress, this court's seminal decision approving independent agencies' for-cause protections, and the ensuing 90 years of this nation's history. Respectfully, I dissent. The 5 men on this Supreme Court are not serious people. They are not adhering to precedent. They are not adhering to the law. They admitted that they were violating precedent. They admitted that Donald Trump is violating the law. They admitted that Donald Trump does not have any cause to fire these commissioners that he has fired. And they acquiesced. They're like, whatever, who gives a shit? Let him do it anyway. That is the nation's highest court. Just looking at the law, looking at the statute, looking at a 90-year-old Supreme Court precedent that is still good law, and looking at this fucking president and just going, it'll all come out in the wash. Who gives a shit? That is a sad, 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 sad opinion in which they did all of those things, and not a single one of those conservative men on today's United States Supreme Court had the fucking balls to sign his name to that order. Not one of them had the fucking balls to sign that decision. That is fucking weak. That is fucking weak. And all 5 of those men deserve their fucking cuck chairs up on that bench. Anyway, if you enjoyed me nerding out for 28 and a half minutes, please click like. Please subscribe to my page. Leave a comment. My name's Hawk. Even if you're going to leave a shitty comment in which you're going to demonstrate to all of us that you clearly don't know the differences between there, and there, two, and two, then, or than, whatever. Just do it anyway, because that's how we spot you guys. That's how we know who we're interacting with. Because you guys are fucking morons. Trump supporters are complete fucking morons, along with a majority of our electorate. Hope that helps. It is late Thursday evening. Tomorrow is Friday. It's the weekend. If you're protesting this weekend, do not give the police an excuse to arrest you or pepper spray you or, fondle your junk. Please be safe, everybody. I mean that. Please be safe. We live in very dangerous times. Please be safe. I'll see you guys soon.